So the next thing we have to look at is this term assignment. And y'all, I'm going to give you an example of assignment of assignment, and hopefully this won't confuse you, but I think it's easier to do. Sometimes it's easier to explain things by just giving you a scenario or an example of how it might work, I think. So let's take a look at this. Y'all, what I'm about to go over with you is something investors do, real estate investors do all the time. This is very common. I will tell you, in my younger years, I used to do a fair amount of this myself. But I'll just give you, I think it was probably the last one I actually did. I just sort of give you the scenario there. Yeah, I found, I used to like to buy houses, sell them. Some of them I'd keep, rent them out, whatever. Um, but this particular house, I noticed it had been sitting there vacant for many years. You could tell bushes had grown up. I mean, it was the house was starting to look pretty rough because it'd been neglected for what appeared to be several years, just sitting there vacant. Well, I looked up who the owner of the property was and got in touch with them and just asked him. I said, look, I keep passing by this house. Nobody appears to be using or doing anything with it, and just curious if you might consider selling it. And he said, I was just thinking about doing that very thing. Funny you should call at this time. So we agreed to meet each other at the house because I told him obviously I'd like to go look at the house, and we did. We went and looked at it. And I will tell you, in the condition it was in, which was not real good condition, I promise you, but in the condition it was in, I knew that house was worth $100,000. Okay, I knew it was. But I decided to make him an offer of 70,000, and he accepted the offer. So we signed the contract, and we had a ratified contract for 70,000. Now, at this moment, now obviously we have not closed yet. All we've done was sign the contract. At this moment, do I, as the buyer, do I own any legal interest in that property right now?
Nope.
That's close. There's no reason, unless you taken this course or some other similar course, for you to know this, and I get that. But I do. And what I now own is what we call equitable title. Now, you don't need to write down what I'm getting ready to tell you right now. It is important, but you're going to see it again later. Okay. I'm just kind of getting ahead of myself to make this example to explain assignment. But the moment a contract is ratified, that means the seller has now conveyed to that buyer what we call equitable title or equitable interest, same thing. Now, I do not have legal title, and obviously I won't get legal title until we do close. But see, under contract law, you cannot get legal title without first obtaining equitable title. You got to get one before you get the other. And this is why, in this example, that seller has now accepted my offer. And let's say 2 or 3 days later, for some reason, let's say he gets another offer, and maybe the other offers for more money. Well, can that seller now decide, I'm going with the other offer because it's more money? Can he do that? No. Why not? Because the seller no longer has equitable title to the property. And that's why. Who has it? I do.
Oh, yeah.
That means I'm the only person in the world today that has the rights to obtain legal title, because I'm the only one with equitable title. And unless I decide to give it back to him, there's nothing the seller can do about it. Right? So Just keep that in mind. Keep that in mind. So I now have equitable title. Well, once I got the equitable title, meaning he accepted my offer, y'all, I started advertising that house for sale. And I put it out there, house for sale, appraises for $100,000 right now, but I'll sell it to you for $90,000. And sure enough, y'all, I forget how long it took, but y'all, I got somebody called me up, said they were interested. They wanted to buy the house and they were willing to pay the $90,000 for it. But can they buy the house if I have the equitable title? No. But can I give the equitable title to the new buyers? I can. Y'all, because it's mine, I can do anything I want to do with it at that point. Y'all, that excuse me. Y'all, that's what we call an assignment, where basically I have assigned my interest, obviously being the equitable title, over to the new buyers. So when I agreed to give them the equitable title through this assignment, what did they agree to give me in return? $90,000, right? So that's the deal. And I will just tell you, we did close. Now, obviously, I didn't really even need to go there because I wasn't the one actually buying the house, because I signed the interest over to somebody else and now they're buying. But the new buyer showed up to closing. Obviously, they had the $90,000 they agreed to pay for it. Now the attorney gave $70,000 of the $90,000 to the seller because that's what the seller agreed to. And then everybody went home happy, happy, happy. Yo, does that make sense?
Yep.
Okay, so when I assigned my interest over to the buyers, did that terminate my interest or right to buy it myself now?
Yes.
Yes. And so that's what an assignment is. That's when someone assigns their interest, whatever that interest is, over to somebody else. That again terminates their interest. Okie doke. Hopefully that makes sense. All right. Now we look at ways to terminate offers. Now, I'm just telling you, here's something else you better be very careful of come test time. There's a difference between terminating contracts and terminating offers. Now, we just went over the various or different ways to terminate contracts. Now we're talking about how to terminate offers. Y'all, what terminates one does not necessarily terminate the other. So don't get these confused. But one way to terminate an offer is simply by rejection. I think everybody understands that. If I make an offer and the other party rejects it, are we done? Yep, it's over. Rejection terminates everything. It renders the contract, renders the offer void. You no longer have anything. Another way to terminate an offer is by making a counter offer. Now, one, I remember that. A counter offer terminates everything up to that point. And here's what I mean by that. And I'm just telling you, you better talk to both your buyers and your sellers about these counter offers, because everybody wants to make a counter offer. Every time you give an offer to a seller, guess what they're going to ask you? Do you think we should make a counter? You think we should counter back? Just get ready for it. Make sure they understand if you do make a counter offer, that terminates everything up to that point. Meaning this, what I think a lot of times, for example, the seller might be thinking, they'll say, you know what, the offer they made, I could live with it. I'd like to get more if I can, but I could probably live with what they offered. But let's go ahead and counter back. I'm going to try to get a little bit more. Now, if they don't like it or they don't want to pay that much, then we'll just agree to the offer they submitted previously. You cannot do that. Once you make that counter offer, you've terminated everything. You've terminated everything up to that point. So you can't just go back and say, oh, I was just kidding, I'll take your first offer. Y'all understand that? Y'all, so just make sure counter offers terminate everything up to that point. There ain't no going backwards from there. Okay. Expiration could terminate an offer. Now, y'all, this is something, if I were you, I suggest you don't forget to do this when you're actually making offers on behalf of your buyer. You should always put in the offer an expiration date, meaning, seller, here's our offer, but if I have not heard back from you by this time on this date, then our offer is terminated. We're done. It's over. It's expired. So you need to put an expiration date. One, to go ahead and get the seller to get off the rear end and let's get something going here. But y'all, how long? Now we'll just tell you in the contract, this will fill in the blank. So there's no right or wrong answer on how long the offer should be good for. It can be as short or as long as the buyer wants it to be. But what do you think might be a reasonable amount of time?
48 hours.
Okay. I think that's very common. It's what a lot of people do. Not unusual. Now, having said that, I will tell you, I'm not sure I understand exactly why that is. And in fact, let me just ask you, why, if you say 48 hours, or if you say 24 hours, or if you say a week, you know, whatever you say, why? Or in this case, why 48 hours?
Because that's what I see on contracts every day.
Okay, very good. Now, keep in mind, y'all, look, there's a reason I ask you stuff like this. And the reason I'm doing it is because, y'all, if I were an actual buyer and you're my agent and you recommend we give the seller 48 hours, what's the chances I'm just going to ask you, okay, well, if that's what you say, that's fine, but I'm just curious, but why? Why do we want to give them 48 hours? Are you going to respond back with that's what everybody else does? Y'all, I'm just saying, you need to, y'all, look, here's the point I'm trying to make. You need to know why you recommend anything you recommend. Okay. I'm not saying what you recommend is right or wrong. I'm not trying to suggest that at all. Just know why you recommend it. Because you need to expect they're going to ask you why. Y'all, everybody just wants to know why. I mean, I don't have a problem with 48 hours. Tell me why. You know, however much time you tell me I need it. Why? I just want to know. I want to know what we're doing here. Right? I mean, if you're the buyer, wouldn't you want to know why? I would. And I got to tell you, if your comeback is, well, that's what everybody else does. If you look at 95% of the offers, that's what you tend to see. Yeah, then that suggests to me you don't know why you're telling me to do this stuff. That makes me nervous. If you can't tell me why we need to do whatever you're suggesting. So, y'all, just know why. Have an answer to these type of questions. I'm not trying to embarrass you now. I'm not trying to embarrass you at all, but I'm telling you, you're going to be embarrassed if your actual client asks you a question and you don't have an answer for it. You know, that's embarrassing. I promise you. I know. So have an answer. Now I will just tell you, not that this even matters at all, but for me, typically the way I like to do it is this. Before we make the offer, I contact the listing agent and I ask him, I said, well, first of all, I let them know, look, we've got an offer and I'm getting ready to submit it and present it to you. But before I send it to you, I need to know when will you get this to the seller? When will you be able to get my offer to the seller? I want to know when the seller is going to get this. And they'll say something, well, Frankie, I mean, obviously they work right now, so they probably get off work around 5. I might be around, say, 6 o'clock, something like that when they get it. Okay, that's fine. I have no problem with that. So what I'll do, first of all, I got to know when the seller is going to get it. Okay. Y'all, now, if they tell me, well, the seller's out of town, so it might be a couple of days before they get back and can actually look at it. Okay. Well, then guess what? I'm not sending my offer until the seller can look at it. And there's no way I'm sending my offer to the listing agent and just let them sit on it. Ain't no way that's going to happen. Nothing good's going to come out of that if you're the buyer. So what I'll do, you're telling me they're going to sit at 6 o'clock this evening. I'll usually put in the offer that our offer will expire at 9 p.m. this evening. Y'all, I usually give them about 3 hours. That's all I'm giving. I mean, why do you need 48 hours or 24 or 72 or whatever? Why? I mean, y'all, if I'm the seller and you send me an offer, I need about 10 minutes to look at your offer, and I can tell you exactly I can tell you if this will work or not. Why do I need days to consider this? I don't let sellers nor their agents sit on my offer like that. Here's my offer. Accept it, counter it, or reject it. One or the other. But we ain't just sitting here. You're gonna do something right now. Why do you suppose I might do something like that? What's the problem with having the listing agent or the seller sit on your offer for a day or two?
They can get better offers or other offers in.
Very good. Y'all, I'm telling you, you send me an offer and give me 48 hours to reply back to you. That means I got 48 hours to start looking for a better offer. I'll start contacting other, hey, look, I know your buyer came and looked at the house. I don't know if they got interest or not. But if they do, I'm just letting you know, we just got an offer, so they better get a good one in quick. If they still have interest on this property. Because see, I can use your offer to shop for better or at least for more offers, right? So no, I'm not giving you time to do that with my buyer. Y'all, that's just me. Again, it's fill in the blank. As long as you got a reason for what you're suggesting, then go with it. But let your buyer know what you're doing. Okay. Revocation. Y'all, can the buyer make an offer and then just decide, you know what? I decided I don't want the house. Could they revoke or rescind their offer after they've already presented it? I mean, we talked about that a little bit earlier, but yes, they can, as long as we have not been notified of acceptance, right? Hopefully you remember that. So you can revoke offers up until you've been notified of acceptance. Now, we'll tell you, even though they notify us of acceptance, does that mean the buyer cannot still back out of the deal? No, they can still back out. You can't make somebody buy the house if they decide they don't want it. But now, could the buyer be liable for damages because they might be in default or breach of contract, right?
Yep.
So y'all, just to be clear, I didn't want you to think they just can't get out of it. But now they can't get out of it without potential damages once it's been accepted. So just be aware of that. Death. Y'all, death has a way of terminating a lot of things, doesn't it? But I will tell you, it will absolutely terminate your offer. So obviously, if a buyer makes an offer and then dies, what do you think the status of that offer is now? It's terminated. It's over. Death will terminate the offer. It absolutely will. And quite frankly, by either party. Okay. Now, and then operation of law. Y'all, could something with the law require any contract that was agreed upon or offer that was made to be terminated? Yeah. Y'all, what could that be? Y'all, could the state decide, you know what, we need this property so that we can build a new highway through here? And then you said, well, wait a minute, I've already made an offer to buy it myself. And can the state say, well, your offers is no good, we're taking it to build a new highway? Can the state do that?
Yep.
Y'all remember that eminent domain, hopefully? Yeah, y'all, that's what we're talking about there. So now we have to take a look at this breach of contract. Kind of touched on that a second ago. But if we agree to the contract, in other words, the contract is now ratified, it's been accepted by all parties, and then one party decides not to buy or seller decides not to sell, then obviously now we're looking at a breach of contract. Now, typically, if either the buyer or the seller is going to be in breach of contract, y'all, who does it typically wind up being, you think? buyer or seller?
The seller.
It's usually more so the buyer. Now the seller does, y'all can the seller say, you know what, I've decided I'm not selling. I know I agreed to the contract. I know I signed it, but I'm not doing it. They can. Y'all have had that happen before.
Or the seller doesn't fix repairs. That's the
Well,
one
okay, well, that's a little bit different. I'm just talking about the seller just decides, I don't want to sell, period. I just decided I want to keep the house. Y'all, again, it can happen. It does happen, but it's not nearly as common as the buyer deciding they've changed their mind and don't want to buy. So it's a lot more common for the buyer to be in breach of contract than it is for the seller to be in breach of contract, even though either one can obviously be in breach. So what happens if either party is in breach of contract? Now what? What are the remedies? And that's what we look at now. Y'all, obviously one remedy is, y'all, you could sue for damages. Y'all, for example, if the buyer backs out, y'all say a couple days before closing, we're notified by the buyer that they've changed their mind and they're not buying. Could that cause damage to the seller because they're not buying now? You better believe it. It could be very expensive. There's no doubt. And I will tell you, if for some reason the seller backs out, that typically could be a lot of damages to the buyer. A lot. So obviously one remedy is you could sue for those damages. There's no doubt about it. You could have a suit for rescission. I remember we talked about rescission here a little bit earlier, but remember, could both parties agree to terminate the contract through rescission? And remember, rescission means both parties agree to terminate the contract. In other words, we're going to release each other of our obligations, and the buyer will get to keep the earnest money. Y'all, that's one option. Again, I'm not saying that's a common option, but obviously it is an option. We could sue for specific performance. Now, y'all, I will tell you, now look, you need to be aware of all of these remedies, but I will tell you, if you're going to get a questions about what are the remedies to breach of contract, this is probably the one they're going to be asking about. Look, specific performance. Because see, here's really what we're dealing with here. Say that buyer a couple days prior to closing decides, I'm not buying. They just back out, not doing it. So the seller decides, we know what, and I'm just making up a number here. Well, if you don't buy, that's going to cost me $10,000 in damage. Now, y'all, I don't know what all that would be for. I'm just saying that's what the seller determined the damages are. Let's just say $10,000. So the seller says, all right, well, buyer, if you're not buying, then you're liable for my damages, and my damages are $10,000. Please write me a check. Now, if that buyer refuses to write the check, what are you going to do now, seller? Well, all they can do is sue the buyer for specific performance. Now, in essence, what you're attempting to do here, again, if you're the seller, you're going to court, and basically you're asking the judge to rule in your favor. Because look, judge, we got a contract here. They said they were going to buy this house, and now for no good reason, they decide they're not buying it. And because of that, I've suffered $10,000 in damage. We want you to make this buyer buy this house. Well, can the courts make the buyer buy the house if they've decided they don't want it? No, they can't. But what the courts can do, because when you sue for specific performance, you're trying to get the judge to force the other party to do what they agreed to do. It's just the reality is, in this case, you can't make them do it if they decide not to. But what the courts can do is say, well, if you don't buy it, buyer, then the seller has proven what these damages are. It does equal $10,000, and you will be liable for that, and you must pay them the $10,000 in damages. Y'all, that's specific performance. Does that make sense? Everybody good there? Okie dokie. And then liquidated damages. Liquidated damages are basically awarded to the party that suffers damages due to breach of contract, even though there was no actual damage or loss of any kind. It's really more so for aggravation, pain and suffering or something, if you will. That's what liquidated damages are. Now, anybody have an idea on how much liquidated damages will be? Any idea there? Y'all, that's going to be your earnest money or the buyer's earnest money. However much earnest money you put up, buyer, that's what's going to be used as liquidated damages in case you default or you're in breach of contract, right? So if you put up $1,000 earnest money, you're going to lose that money unless the seller agrees to give it back to you if you don't buy. Okay. That's what liquidated damages would be. So any questions about what the relief would be? We good? Everybody happy? All right. So now, what we're going to look at right now are the common provisions you would see in an agency agreement. Y'all remember when we talked in chapter 1, talking about agency, when you're representing the buyer or the seller, if you're going to represent them, do you have to have an agency relationship to represent them?
Yeah.
Meaning you got, if you're listing a house for sale, meaning you're representing the seller, you got to sign a listing agreement. That's an agency agreement. Or the buyer's agreement to represent the buyer. Again, that's another agency agreement, obviously, for the buyer. So what we're getting ready to look at now are the common provisions you would see in a typical agency agreement. Now, there's quite a few of them here, but look, what I don't expect you to do, do you need to memorize all the provisions in an agency agreement? No. They're not going to ask you on the exam, list all the provisions in an agency agreement. They're not going to do that. But could they ask you questions about any one of these provisions? They can. So you do need to make sure you understand what the provision is or what the requirement is in case they should ask you a question about it. But don't try to memorize all the provisions that you might see in an agency contract. That's not necessary. So let's take a look at them. Number one, we have to know what the property data or requirements would be. Obviously, if you're listing the house for sale, there's a lot of information or data you need to know about that house. We're not going to get into all that right now. That's for the Unit 2 class that you'll be taking. But I will tell you, it's about 4 or 5 pages of information. It's a lot of stuff you got to know about that house. Obviously, the site, the square footage, number of bedrooms, number of bathrooms, school district, zone. There's a lot of stuff you got to know about it. And that's what they're talking about here. Or if you're representing the buyer, obviously with the buyer's agreement, then now we got to know what are the requirements the buyer's looking for. The buyer might say, well, we're looking for a 2,000 square foot house, got to have at least 3 bedrooms, minimum 2 bathrooms, certain area of town, whatever. And then whatever they tell you, you got to write down those requirements that they want in the agreement. That's what they're talking about there. Now, the next thing you'll see, it says you must be able to distinguish between what's realty, personalty, and fixtures. In other words, make sure your client, buyer and or seller, make sure everybody knows what's staying and what's going. I'm telling you, this is one of the biggest problems we run into in real estate. And in my mind, that's just negligence on part of the real estate agent. Because a lot of times you'll have the seller thinking, I'm not leaving something, but the buyer's thinking when they make the offer, they're going to get it, that it'll be staying, right? And that's where these fixtures come into play. Y'all, do fixtures stay or go once the house goes under contract? Y'all remember that?
Stay.
They stay.
It's staying. There you go. But can you see where a lot of times the seller may not they might not know that and think they're going to take it with them. In fact, I'll give you a very common example, believe it or not, where it used to be a lot more common than it is today. You don't really see this now as much, but yeah, I'll just tell you, if you're listing a house for sale and happen to have a formal dining room, again, you don't see formal dining rooms, not as common as they used to be in a lot of houses, but yeah, if there's a formal dining room, a lot of times they'll have a really nice chandelier. Well, the first thing you better ask that seller before you put the house on the market, seller, are you planning on leaving that chandelier or are you planning on taking it with you? And y'all don't be surprised and say, oh, Frank, yeah, I can't leave that chandelier. I mean, that chandelier has been in my family for 10,000 years. Ain't no way I'm leaving that. Okay, well then fine. But you need to go ahead and take it down now before we put the house on the market and put something back up in its place. Y'all, if you don't talk to your clients about this, y'all, they're going to be thinking they can just take stuff that they can't take, right? And once the house is under contract, now it's too late. Seller, you've lost it. It's gone. That buyer has every right to it. Otherwise, you're going to be in breach of contract, seller, right? So y'all just be careful with this kind of stuff. Make sure everybody's very clear on what's staying and what's going, what's included, what's not. If you're listing the house for sale, we got to agree on a sales price. If you're representing the buyer, you need to agree on a price range. Y'all, the buyer might say, I'm looking for something anywhere from say 140 to 155,000. And then you look for houses somewhere in that price range. We have to agree on what the commission will be. Y'all, and by the way, how do we determine commissions? How's it determined?
Negotiated with the broker.
Well, not with the broker. Who's paying the commission?
The seller.
The seller. So you and that seller are going to have to negotiate that commission. And the point is the commission is always negotiable. I'm just going to tell you, this is something, especially when you're starting out, in fact, I'm just going to tell you, here's a question you might as well get prepared for. But y'all, and I'm just making up numbers right now. Okay. This is not suggest what you should or shouldn't do. I'm just trying to make a point. But y'all, what's the chances the seller will ask you, well, how much commission do you charge? Guaranteed. And then, y'all, and again, I'm just making up a number. I'm not saying this is what you should or shouldn't charge, but let's say my response is, well, I charge 6%. Then what's the chances they're going to say, well, why 6? Y'all, if you're the agent, what's your answer? Why do you charge 6%?
Because you split it with the selling agent.
Okay. Well, why do they need that much? Yeah, I'm being kind of a horse's rear, and I don't mean to be right now. But my point, I'm telling you, you better be ready for these questions, because you're going to feel ridiculous and you're going to look ridiculous when they ask you questions and you don't have an answer for it. Because y'all, look, at the end of the day, y'all, can your broker in charge tell you how much you're going to charge? Yes, y'all, because who are the parties to an agency relationship? The principal, which would be either the buyer or the seller, and the agent. And who is the agent? The broker in charge. There you go. So can the broker in charge tell you, if you're one of their licensees, how much you will charge? Yes, they can. However, and I know this sounds kind of wishy-washy, and I don't mean for it to sound that way. But at the end of the day, y'all, what you cannot do is for example, if that seller says, Frankie, why do you charge 6%? And then my response is, well, that's what I think you'll find that's pretty much what everybody charges. That's the going rate. Y'all, that would be illegal. That's a no-no. Because when you answer that way, you're now suggesting the rate is set. Y'all, that's a violation of antitrust laws, which we hadn't talked about that yet. It's coming up in another chapter. But just, y'all, that's a no-no. Y'all, antitrust laws says you cannot set the rate, okay? The rate's always negotiable, and that's the way you have to do it. So y'all just be ready to answer the question. And I'm not trying to say that you have to agree to lower whatever you're charging. You just cannot suggest that it's set and I can't set it. I just tell them, say, look, this is what I charge. Here are the services I provide. It's well worth, in my opinion, this is what my services are worth, and this is what I charge. Now you're welcome to find somebody else if you don't want to pay that, right? But don't try to tell them that or suggest that it's set and you don't have any leeway here. I could reduce it, but I might choose not to as well. And that's fine. Okay. Moving on. Obviously, there has to be signatures of both the principal, and again, remember, the principal would be either the buyer or the seller. That's whoever you're representing, and the agent. Now, who's the agent? The broker in charge. So, if you think about this, will you, as the licensee, be signing agency agreements? You shouldn't, because you're not a party to the contract, right? You're a sub-agent to the agent. So only the agent and the principal should be signing the agency contract. Does everybody understand that? We're good? All right. There has to be a specific expiration date. For example, if you're going to list the house for sale, there must be an agreed upon expiration date for that listing. I will just tell you, this is one provision they do like to ask about. And I will tell you, this is a mandatory provision you better have agreed upon or agreed to in the contract. If you ever get caught, say, listing that house for sale and you just left that blank, you did not fill in an expiration date, that's illegal in South Carolina. That's a no-no. So this is not an option here. You better have agreed upon an expiration date. Now, the law does not say how long you have to list it for or how short. It can be for as long or short as you want it to be, but you better agree, you and your client must agree on an expiration date. So just be clear there. Now, the other thing you'll notice, again, still talking about the expiration date, you cannot have an automatic extension clause in the agreement. So, does everybody know what an automatic extension clause is? Anybody not know?
I don't know.
Okay. Could I say this is going to expire? Let's say I'm listing the house today, and this house, the listing will expire on August the 30th of 2021. But then right underneath it, I put this provision there that says, seller, if you really want this listing to expire on August 30th, then you must notify me in writing within 30 days of it expiring, or this listing will automatically renew itself for another 4 months or 6 months or whatever. That's an automatic extension clause. You cannot have that, not in South Carolina. That is not legal. Okay. Now, once it expires on August 30th, or maybe a day or two before, can me and the seller agree just to extend the listing for another few months or whatever? Yes. You can do that. You can do that. You just can't write in there that it will automatically extend. Can't be doing stuff like that. That's a no-no. All right. Obviously, we have to include in the agreement whatever services you agree to perform. So whatever you tell that seller you're going to do to sell your house or sell their house, that has to be put in the agreement. Whatever you tell the buyer you're going to do to help them buy the house, you better make sure that's included in the agreement. All that has to be there. We all have to agree on how and when the agent earns compensation. You know, in fact, let me just ask you, at what point has the agent earned their commission? Anybody know?
Closing.
And I will tell you, that's the most common answer. In fact, I will tell you, I'd be willing to bet if you ask 10 veteran real estate agents that question, at least 9 of those 10 will give you the same answer at closing.
It's at offer acceptance when they earned it, not when
Very
they
good.
paid it.
Very good. Y'all, the commission is earned at the moment the contract to sell is ratified. Meaning they've agreed to the contract. I've now earned my commission. Y'all, so in other words, does the buyer and seller have to close for me to get paid now? No. You still owe me my commission. So say, for example, buyer, if you want to walk away or terminate, look, I can't make you buy the house, but can I make you pay my commission if you decide not to buy it? Yes, I can. And I will tell you, if it's me, you're going to probably have to pay it because I got children and they like to eat. But so y'all, if they ask you something like this on the exam, and good chance they will, just understand the commission is earned once the contract is accepted or ratified. Now, there is verbiage there that says that we agree to put off payment of the commission until closing. And y'all, what it's saying there is this: as long as you close, then I'll get paid at closing. But don't misunderstand and think we have to close for me to get paid. Because if you decide not to close, you still got to pay me my commission. Does everybody understand that? Hopefully that's clear. Yeah, a lot of veteran agents don't get that. I promise you. Yeah, I'm talking to them, teaching them all the time, and it's amazing. But anyway, all right. Yeah, you'll also see in the agreement where if you choose to, you can charge retainer fees. Now, y'all, a retainer fee is some amount of money that you're charging your client up front. Y'all, before any services are provided, I want you to pay X amount, and y'all, that amount will be whatever you and your client agreed to. But this will be paid up front before I provide any service. Y'all, that's a retainer fee. Now, if you're going to charge a retainer fee, now we'll tell you that is, at least around here, not very common at all. You hardly never see it. But if you want to charge it, obviously you can legally charge it. And as long as your client agrees to pay it, then there's no problems there. But what you also have to agree to is this. Yeah, I'm just making up a number, but let's just say you charge $500 retainer fee. Well, then the question now is, will that $500 be deducted from your commission at closing? In other words, is that going to be part of your commission, or is that going to be over and above whatever you agreed to the commission to be?
Over and above.
Well, it can be either way. Again, it can be whatever you agree to, but you got to make sure that's agreed upon in the contract.
Gotcha.
So you got to agree upon, 1, are we going to pay it or charge it? 2, how much is it going to be? And then 3, is that going to be part of my commission, or is this over and above whatever the commission will be? But all that has to be agreed upon if you're going to do it. It says we have to agree on the type of agreement. Remember, again, when we were going over agency, remember that when we went over the types of agency agreements in that module. But you remember, you could have an open listing or an open buyer's agreement. You could have an exclusive agency agreement. You could have the exclusive right to represent or the exclusive right to sell. Y'all remember that, all that? Hopefully. Y'all making me nervous. Y'all remember that?
Yes.
Okay,
Yeah.
thank you. Thank you. Just want to make sure you're not nodding off. Again, so it's just saying you got to make sure that it's very clear what type of agency agreement you're entering into. If you're going to have exceptions or variations to the commission, that has to be included in the agreement. Now, the more common term you hear a lot used with, I mean, in the industry, we call this a variable commission, which, and that's legal. Y'all having a variation or a variable commission, that is legal to do. But y'all, what they're talking about here is this. And again, I'm talking about commission right now, but this is not to suggest what you should charge or not charge. I'm just using this as an example. But let's say, I could just tell my seller, I'm going to charge 7% commission to sell your house. Or I could tell the seller, I'll offer a variation, or what we call a variable commission. And by doing that, what I might say is this: seller, I'll charge you 7% commission, but if I can find the buyer myself, in other words, there are no other agents involved, then I'll only charge you 4% commission. That just means there's some variable that dictates how much the commission will be. If this happens, I'll charge this much. If this happens, then I'll charge this much. That's called a variation or variable commission. Now, again, those are legal. You can do that. But I will tell you, again, the law requires, if you charge a variable commission, if you and your client agree to a variable commission, that has to be disclosed to all buyers and their agents. You've got to let, before they make the offer, you've got to disclose to that buyer's agent that me and my seller have agreed to a variable commission, and here's what it is, and here's how it works. You must disclose the details. I'm telling you, you get caught agreeing to a variable commission with your seller and you never disclose it to that buyer, that's a problem. So just beware. Then the next thing you see, it says you must provide a copy to your client. Obviously a copy of the agreement. Your client must get a copy of it. Now, we need to talk about this one here just for a second, because I'm just going to tell you, and I've had, especially here lately, I've had several people come back and tell me this was a question they had on the state exam. And basically the question is, at which time must the client receive a copy of the listing agreement or the buyer's agreement or whatever? And obviously one of the answers probably something like, as soon as the client signs the contract, then you got to give them a copy of it. Who all has to sign this agreement? We just talked about it, but who has to sign the agency agreement?
The broker and the principal.
Very good. The broker in charge and your principal. Well, let's say I'm listing a house, and typically, where are you going to be when you're listing the house? At the seller's house, most likely. So the seller signs it. Well, guess who has not signed it yet? The broker in charge. So does it make sense that you would give them a copy of that agreement when they sign it, even though the agent has not signed it yet? No, that's useless. The contract's not executed yet. So when you get a question like this, look for the answer that says something along the lines of once it's been signed by all parties. Because the reality is, if I'm the licensee, seller, I'm getting you to sign it, but now I have to take this back to the office and get the broker in charge to sign it. Now, once they sign it, now I need to get a copy back to my principal, whether it be the buyer or the seller. Does everybody get that? Because apparently the way they word that question, it makes it look like the right answer is as soon as your client signs the agreement. And that's not even practical, because you're not going to have the broker in charge riding around with you everywhere you go. All right, so y'all, hopefully that was clear. Not a problem there. Y'all, then you see this broker protection clause, and y'all, that's a clause or provision that does exactly what it sounds like. It's a provision to protect the broker. Believe it or not, there are some unscrupulous buyers and sellers that will, if you're not careful, y'all, they'll go behind your back and try to cut you out of this deal, and they'll do it. And y'all, what has happened a lot, and we don't see it so much now because we now have this provision. But before this provision was included in the agreement, what you would have happen a lot of times, y'all, a buyer would go behind your back. It might be your buyer, but they'd go behind your back, talk directly to the seller, and ask the seller, when does your listing with your agent expire? And the agent says, well, as a matter of fact, it expires in the next month. Okay, well, I'll tell you what, seller, if you'd be willing to wait till the end of next month, let the listing expire. I'll buy your house and I'll pay you full price minus whatever the commission would have been. Can you believe people would do stuff like that? Just trying to cut the agents out of the deal. Y'all, I'm telling you, it was at a time they're fairly common. But that's what this clause does. That protects the broker from that kind of nonsense. And basically what it says is this. And obviously I'm paraphrasing, but basically what it's saying is this: seller, if you should agree to sell your house to any buyer that looked at your house while it was listed, but then you agree to sell it to them after your listing expires, you still have to pay the commission. As long as, if you're selling to somebody that looked at it while it was listed, then you still have to pay the commission even though it expired. Now we'll take, you do have to put a certain number of days, 100 days, 50, whatever amount of days you want. But it might say, if you sell to somebody within 100 days of it expiring to somebody that looked at it before it expired, then you still have to pay the commission. That makes sense, right? Or did I confuse you more? Everybody good there? All right, then you have a question?
No.
Okay. All right, and then there's the multiple listing clause. And that's the provision that says if you list a house for sale, you must enter that house, that sale or listing into the MLS. Y'all, this is not an option. Y'all, if you get caught listing a house for sale and you don't put it in the MLS, now you are afforded a certain amount of time. It depends on the MLS on how much time you have, but it's not a lot of time. It's usually like 48 hours. You have, from the time you list it, say you got 48 hours to get it in the MLS. If you get caught holding it out of the MLS, I'm going to tell you that could result in fines, and if it happens multiple times, it could result in expulsion from the MLS, which means you're pretty much done with residential real estate if that happens. Okay, any questions about that? All right, so y'all, that's all the provisions in an agency contract.